Picture this scenario. A client walks into your office, and they are incredibly anxious. They've just been handed a court notice for a relatively minor offense. Now, they are completely confused about what's going to happen next. And quite frankly, if you're a law student or a newly practicing lawyer, you might be a little unsure yourself. Are they facing a summons case, or is this going to be a summary trial? And does that distinction actually even matter?
It absolutely matters, Bisma, way more than you might think. If the court applies the wrong procedure, the entire trial could be completely compromised.
Welcome to this explainer on Pakistan Legal Insight. I'm Amr, and today, Bisma and I are going to demystify the magistrate court's procedural tracks for lesser offenses. We are breaking down summons cases versus summary trials. Let's get right into it.
Okay, so part one. Let's establish the baseline here with summons cases.
So, Ahmed, to start us off, what exactly qualifies as a summons case under the Code of Criminal Procedure?
Well, Section 4U of the CRPC actually defines a summons case by what it is not. It's defined by exclusion. So it's any offense that is not punishable with death, life imprisonment, or imprisonment exceeding 2 years. If the punishment hits that 2-year and under threshold, we follow this simpler, more streamlined baseline procedure, which is governed by Sections 251 to 259.
Wait a second. Just going through the procedural steps. There is no formal written charge sheet? We just covered warrant cases recently where framing the actual charge as this massive, absolutely critical step in the trial.
Right, exactly. And that's a huge distinction. Under Section 251, the magistrate simply states the oral particulars of the offense to the accused. There's no formal, written charge required before asking them to enter a plea. It's much more direct.
But if the procedure is that simplified, and you don't even need a formal written charge, does that mean it's somehow easier for the prosecution to just get a quick conviction?
No, absolutely not. That is a really dangerous misconception. The Lahore High Court made this crystal clear in the 2009 precedent, Fayaz Ahmed versus the state. A conviction based on a bare statement without any solid corroboration is going to be highly scrutinized. The simplicity we're talking about relates only to the administrative procedure. The prosecution still has to prove guilt beyond a reasonable doubt every single time.
Makes sense. Okay, part two, summary trials, or what we can think of as the fast track. So, what happens when the crime is incredibly minor? How does a magistrate court speed things up even further than a summons case? The defining feature here comes down to one crucial limit: 3 months. Under Section 261, the absolute maximum sentence a magistrate can award in a summary trial is 3 months. It completely ties their hands, regardless of what the standard penal code sentence for that crime actually be.
A strict 3-month cap. So what kind of crimes are actually qualifying for this ultra-fast summary track?
Amr's Section 260 lays this out. Generally, it covers offenses not punishable by more than 6 months imprisonment. But to really put it into perspective, look at some of the specific examples the law provides. Theft or receiving stolen property where the value of the property does not exceed 50 rupees. 50 rupees! That just goes to show you how extremely minor these cases are intended to be. It also includes things like lurking house trespass by night and any abetment or attempt of these specific offenses.
Okay, but if we're talking about a dispute over something worth 50 rupees, and the trial is literally called summary, does that mean the magistrate can just skip hearing the defense entirely just to save the court's time? Never. And honestly, this is a trap that some lower courts have fallen into in the past. In the 2011 case of Kaiser Ali versus the state, the Lahore High Court ruled very firmly that maintaining an abbreviated record does not mean you can just convict someone without hearing their defense. Being on a fast track does not mean you get to skip the basic rules of natural justice. The accused must be heard.
Part 3. Putting these procedural trade-offs head-to-head. So if I'm sitting in the courtroom taking notes, what are the exact mechanical differences I'm going to see between the two?
Amr, mostly it comes down to record keeping. In a summons case, as we mentioned, the magistrate states the oral particulars. But in a summary trial, under Section 263, the court maintains a highly abbreviated, bare-bones administrative record. It's essentially a heavily condensed version of a standard trial record.
Wow, when you compare the evidence recording requirements, the difference is massive. A summons case actually requires all the evidence to be taken down.
Exactly. Under Section 255 for summons cases, the magistrate has to take all the evidence produced by both the prosecution and the defense. But in a summary trial, Section 264 says the magistrate records evidence only where necessary for the ends of justice. That gives the magistrate immense discretion to just note down what is absolutely necessary and then move straight to judgment.
And just as a quick reminder on the sentencing contrast,
A summons case allows the magistrate to sentence up to their normal jurisdictional limit, which is generally up to 2 years. But the summary trial is that hard absolute cap of 3 months max.
Okay, but here's a hypothetical. What if halfway through a summary trial for minor theft, the magistrate realizes this accused is actually a repeat offender, and they really deserve a full 6 months? Are they just permanently stuck with that 3-month cap? That's a very smart question. Actually, no. Under Section 262, if it appears during the proceedings that a sentence of more than 3 months is going to be appropriate, the magistrate cannot just break the cap. They must hit pause and convert the case to the ordinary summons or warrant procedure. The severity of the punishment ultimately dictates the procedure.
Which brings us to Part 4, why this procedure actually matters in the real world.
So, why should young lawyers be so totally obsessed with knowing exactly which track their client is on?
Because applying the wrong trial procedure is what we call a material irregularity. If a magistrate tries a much heavier case using the speedy summary track, the appellate courts will heavily scrutinize it, and they will likely invalidate the conviction. You have to know your jurisdictional tracks, or the whole trial falls apart on appeal.
But, and this is absolutely vital to remember, regardless of whether you are in a standard summons case or a lightning-fast summary trial, the golden thread of criminal law remains entirely intact. The benefit of the doubt always goes to the accused, and the standard remains proof beyond a reasonable doubt.
All right, let's wrap this up with Part 5, the summary and key takeaways.
Ahmer, can you just boil this entire discussion down into the main points for anyone taking notes?
Happy to. Point 1, summons cases cover offenses up to 2 years. Summary trials are for very, very minor offenses. 2, summary trials have a hard 3-month sentencing cap. 3, summons procedure requires the magistrate to take all evidence. Summary only requires recording what's strictly necessary. And 4, both of these procedures dispense with a formal written charge sheet. You know, it's really clear that while our courts desperately need judicial efficiency, there are very strict guardrails in place to ensure corners aren't being cut. Whether a trial takes 3 days or 3 years, the fundamental right to a fair defense has to stand firm.
Exactly. And that brings us to the end of today's explainer. Remember, this discussion is purely for legal education purposes and does not constitute legal advice. Please always consult a qualified advocate for specific cases. But we want to leave you with this final thought to ponder. In the relentless pursuit of clearing court backlogs, how do we guarantee that the speed of a trial never outpaces the standard of justice? Thanks for joining us on Pakistan Legal Insight, and we'll see you in the next one.